So, good morning, ladies and gentlemen. We will discuss one of the biggest issues in this AGM season. We saw a lot of articles in the newspapers about very low quorums on the AGM of companies with registered shares. A lot of non-domestic holders account for a drop of 30 to 20%, as most of them either only register a small part of their holdings or did not vote at all. So could we predict this? We tried to discuss this this morning. We show you a small overview of what happened with the quorums. So you can see from the DAX companies with registered shares what happened. So the quorums are very low, and this is a situation which is not very good for the companies. And the good thing this year was that most of these companies didn't have any critical issue on their agenda. So what was the reason behind this low quorum of the AGM? The Cologne Higher Regional Court decided on the 6th of July 2012 that for listed companies with registered shares, nominees need to publicly disclose their holdings. And if they pass any threshold of the mentioned in the WPAG, they should publicly disclose. So, as nominees are not willing to do this because they are not the beneficial owner for the shares, and so they're unwilling to comply with this court ruling, and they see it as a conflict with their own rules. And that's the reason why they want to do it. They don't want to do it. As a result, banks started to register the beneficial owners who wanted to vote. And this led to a complex process and for soft blocking in the banking systems. As a result of this, a large number of investors abstained from voting, as they were concerned that they would have trouble selling or transferring the shares, and so they decide not to vote. This is, in short, what we are discussing, what's the issue. And we want to discuss this from the several point of views of the market participants. We have from the investor side, Julia Wittenburg, from BlackRock. From the issuer side, Jens-Jürgen Vogel from Munich Re. And from the proxy solicitor side, Cas Sydorowitz from Georgeson. And we will discuss this issue right away. So Jens, please, what were the consequences of the OLG judgment? And how does the registration process work from the issuer's perspective?
Yes, a little step back to the decision. From the issuer, you have the shareholders in your share register, and in the past, only beneficial owner have to make these announcements when they cross the 3, 5, 10%. And the decision was that also nominees have to make an announcement when they cross 3, 5, 10, and so on %. So what's the result? It's all these shareholders that cross this percentage will lose their voting rights for 6 months. So if a shareholder cross one of these points, he will lose it, and we have to look 6 months back before the AGM to every shareholder who has crossed one of these marks. So we made an analysis, which one is it, and these were 10 or 12 shareholders, and all of them were nominees. So these nominees held these shares on behalf of other participants. For example, for BlackRock, and in the register you only see, for example, State Street Bank, and they have 10–15%, and BlackRock made these announcements years before, and so they have the voting rights, but they are behind State Street, and in the register we only see State Street for the issuer. We only see State Street, and they don't have any voting right. So this is a difference to the past, and what does it mean for us? We have the BaFin as authority in Germany, and they say we will put any fine on you if you don't make an announcement. They won't put a fine on the investor side. They don't put a fine on the issuer side. But the problem is that every shareholder, so also if he had one share, can go to a court and say, oh, there is a registration for State Street, but they have more than 3%, and they never made an announcement, and they had lost the voting rights. So every shareholder can say, I go to the court, and your AGM decisions are not made because you made something wrong in the registration process, because they had not to vote in the AGM.
Sorry to interrupt. That actually happened this year. Deutsche Bank had a situation where their 2012 AGM had to be recalled in April of this year for procedural matters that shareholders weren't permitted to speak for or have all of their questions answered during the meeting itself. So it's not an empty threat. We've seen it already this year.
Yes, and it's public, especially for the critical shareholders. They saw it. They saw the decision from the court, and if you make something wrong, they will come and go to the court, and then we have to repeat our AGM next year, and that's very expensive. So what have you done before the AGM? We go to the investors, we go to the nominees, we all send them letters, emails, and so on. We informed them, and we tried to start a discussion. We informed our proxy solicitor, and it was very difficult to explain the new situation to all the nominees, Cas, I think.
Very much so. It was a process by which was evolving during the proxy season, where custodians learned of this early on, and I think after the first registered shareholder meeting in January this year, started to realize that more work needed to be done, and the procedures and how it was communicated ultimately to shareholders evolved also during the proxy season.
So, Julia, from your side, how does the process work from the investor's perspective, and how are your internal process set up to carry out your voting rights?
Absolutely. So first of all, voting is an integral part of our corporate governance principles, which is to protect and enhance the economic value of the companies that we invest in. We do this through talking to management and to the boards of the companies, but we also, when the client has given us the voting authority, we also vote at shareholder meetings. In our case, maybe just as a background, we vote all shares managed by BlackRock in one given company, and we vote using a platform provided by external service provider, so which is our voting agent. we vote our consolidated share position in that particular company, and that usually means that we will be voting through several custodian banks. So in an unconstrained condition, such as in a record date market, we submit our instructions via the platform, and then the instructions get passed down the voting chain back to the company in the company's share register. Now for German companies with registered shares, and I think it's important to clarify that this is this particular issue applies to registered shares only, not to those companies with bearer shares. There is a visual marker on the voting platform that indicates that there is a soft block. The marker is essentially an indication that the shares that have been instructed to vote need to get registered on the company's share register, and that they need to be deregistered if an instruction to sell the shares comes through. So when a share sale is executed, the soft block that is in place may lead to a delay in the trade settlement. I'm not sure if that gives you a little bit of a flavor of how we would be looking at the situation when voting at a company that has registered shares. So the concern from an investor perspective in this respect is that any type of delay in settlement could lead to a temporary liquidity constraint, which may lead to a failed trade, which then again implies cost, has cost implications for us and our clients. So essentially, there's an operational risk when we vote at a meeting where a soft block may apply.
Okay. Cas, from discussions with issuers, I very often heard that institutions like ISS and Broadridge are part of the problem because they misunderstood the process of registration and deregistration. What is your opinion on this?
I'd answer it this way. In terms of the difference between ISS and Broadridge, they both play fundamental but different roles in the overall process. ISS as a proxy advisor supports institutional investors, and besides monitoring the portfolio and letting the investor know what meetings are coming up, what agenda items are available to vote on, what procedures. Without that process, I would suggest that many institutional investors wouldn't be able to vote at the sheer volume of meetings that they do currently. It's an essential role. They are taking instructions from the various parties between themselves and the issuer. So what does that mean? In Munich Re's case, they will issue the notice of meeting that goes out into the market and is posted on your website. That is also communicated to the local banks in Germany, who then interpret that and input that information into their communications to the global custodians. Most global custodians outsource the notification and collection of votes to either Broadridge or ISS. They're the ones being notified. They're the ones who are providing the electronic platform for most overseas investors. The instructions that they receive are being, remember, Broadridge, in effect, works for all of the various global custodians. They represent the vast majority of the top 10 or top 15 global custodians, with ISS, a different part of ISS, representing the remainder. They're taking instructions from their custodians. Their custodians have, after reading and learning about this court ruling, have taken a very restrictive interpretation of that ruling and said, we don't want to be at risk or wear any liability for ourselves or for our clients. We have to put our clients' names on the register. I don't think they're necessarily at fault in this. They're certainly not to blame. They're passing on instructions. I will say that it's important to note that certain custodians apply the soft blocking or the flagging on accounts. Other custodians do not. And I guess what we would like to see, and one of the challenges that exist, is have the communication be specific down to the specific custodian. So if a custodian does not apply blocking, alert those clients of that investor that blocking does not apply. And I believe, Julia, at least one of the two have that differentiator on their systems.
So yeah, I agree. So essentially, the two providers, ISS and Broadridge, essentially they pass on the messages from the global custodians. So these get put on the voting platform, which is that marker that I was mentioning earlier. That is, in that sense, Broadridge and ISS are a messenger from the global custodians and providing any type of flag that may impact voting at that meeting to the investor.
So, Jens, so what issues do you face? So, did you need to explain this to the board member, and or what do you do internally?
Yes. We had a lot of discussions internally, but I think it's not the issue to discuss it internally. It's more the issue to discuss it with the banks and the market participants. And for that, we had, as I mentioned before, 10 to 12 shareholders where we had intensive discussions with, but most of them were banks. And we were one of the first companies who had this process. Just, I think, Daimler and Siemens and Infineon were before us. So they said, okay, we will make the process like the last years because you have something in your articles of association, and we had done this in the years before. It was no problem. In the last year, we had around 50% of the shares in our AGM. And we thought, okay, this might be no problem because the process is the same. They will send out some Excel files. There, the investors have to put in their shares and their votings. And they said, we make a little bit difference in registration because Deutsche Börse set up a new interface where they manually can put in these data, and we will send it via this interface to your share register.
Sorry, can I just pause you for a moment?
Yeah.
It's just useful for everyone in the audience to hear what you've just said. Excel files, manual processing, a new system that was just introduced. In the last session, they talked about 70% or 65% trading in dark pools of German securities. How is it that we still have, there's a fundamental question here, I don't mean to interrupt you, but how is it that so much of the process in and around voting still requires Excel? We're so much past that, and manual re-registration and processing. It's striking to me that how trading has evolved so much farther ahead of the processing of votes. It strikes me as a catch-up is needed on the technology side. Sorry, I didn't mean to interrupt you, but it just was striking to hear all of those things, one after the other after the other.
Yeah, that's the point we see. We need a bank to discuss it more in detail because they handle like this. And I think this is one of the issues we have, that the process is manually done and that we don't have an automated process that everything will go straight through from the investor directly through the systems to Cascade ARS, the Deutsche Börse system, into the share register. So if we had a completely electronically process, it would be, I think, very easy for everyone to go through the chain to register the votes for the AGM, and I think then everything will be fine. But I think we are away from this.
So when we hear about manual processes, Julia, you mentioned this morning the number for how many AGMs you vote per year?
Yes, I think that is important to put into context. So at BlackRock, we vote at 14,000 shareholder meetings every year globally. So putting that into context with the manual processes, one of the challenges that we're facing is that because this process is the process is pretty new, and we use several different custodian banks, we have observed that many of these banks are using different processes. So that makes that
Much
creates
more
an
complex.
extra challenge for us, in that sense that, for example, we did in 2 instances vote at shareholder meetings with registered shares as a test to see how well or what type of impediments we would be facing. And we observed that some custodian banks, we would have to, in order for our trading teams to be able to sell any shares that were registered for voting, we had to not only ask the custodian bank to deregister the shares, but then separately also call them and ask them to recall our vote. So those were a two-step process. And that was not applicable to all custodian banks. So some of them have already very well automated processes. Others, as you said, Cas, will have more of a manual process in place that will require to segregate information from an account onto an Excel spreadsheet that will then be passed on. And so that makes it quite inconsistent at this time. There is no real uniform process in place right now that will allow us to minimize the operational risk that we see when we're voting at meetings such as registered shares.
Okay, and Cas, I think the work in proxy solicitation was very intensive this year, much more than in the past for companies with registered shares. Was it only registered shares where the impact of this court decision, or?
No, it's an excellent question. Many investors looking at the marketplace, just as Julie described, came up with similar findings that there were different procedures by different custodians. The timetable seemed to shift in terms of when instructions had to be in over the proxy season. And some investors thought this was just too much of a burden for them. And so we've talked to many investors who decided they would not, or only vote a portion of their shareholding. So in one instance, Legal in General told us they would vote 20% of their shares. And that applied to both registered and bearer shares. So while the slide that you showed before on registered companies, I would expect there's probably a similar decline, although not as drastic, for bearer share companies. Not all investors had that reaction. Templeton took a position that they would only vote a small percentage of their shares at German registered companies, but they wouldn't be impacted at all for their voting at bearer share meetings. Interestingly, Nordges Bank, one of the largest investors as a sovereign wealth fund in many German companies, had a discussion with their custodian and put in place procedures where their custodians would not apply this soft blocking for them specifically. I think that's partly due to a few things. Julie, you mentioned it before, that their shares are in segregated accounts at the global custodial level. And secondly, that they're an investor of such a size and significance for any single custodian that they can apply a level of pressure that perhaps much smaller shareholders can't in terms of getting their custodians to take the necessary additional steps. In interest for some of the meetings that we worked on, we saw Nordges vote their full position. So in a very different relationship to considering voting, they took the position that they were comfortable that that operational risk that Julie described was sufficiently mitigated out with those separate relationships, and that permitted them to vote. Others, it did impact both registered and bearer shares.
And I think what also happened is this change in the process was a little bit of a surprise. So how was you informed about this?
Yes, I think that is a very good observation, in that we were notified of the change in process once we voted at the first meeting this year in January, where of a company that had registered shares. So we had already submitted our vote instructions when we were notified by our voting agent that there would be a soft block. So that was quite a big surprise for us, considering that that had not been the case in Germany for several years, any type of blocking. So we decided to leave the instruction as is, since it was still very early in the voting season, and actually voting season hadn't started at the time, and we kept a very close eye on what was happening. And then within a few days, we got our first notification from our trading team saying that they saw a proxy restriction, a voting restriction in place, and that they could not sell the shares. Now, just to clarify, and you brought this up earlier, Götz, is once proxy season evolves and we're in the peak of season, we're voting so many meetings and we have so many different global, so many trading teams globally that we can't really keep up with all the notifications that we will be getting from all over, really, all over the planet, really, if a trading team wants to sell their shares. So in this particular case, we had to lift the restriction directly with the custodian, and then we had to recall our vote. And then, again, if this were to happen in a situation of peak season, we would only be doing that. We would only be putting in manual instructions in place and having to keep an eye on multiple meetings, dozens of meetings. I think there's a question there.
Yeah. Yeah, you can ask is there something with a microphone? No? It's coming.
Yeah, I don't want to interrupt the discussion, and probably
No.
we'll have time to discuss afterwards as well, which would be very helpful, I think. But as you said, Julia, you were kind of, I mean, you're the customer of the custodian bank. So if the custodian bank burdens you with any soft blocking, first of all, it's important to clarify that under German law, there's no blocking, there's no share blocking, and there's also a kind of record date system. So if you're registered the day 7 days before the meeting, you can deregister 6 days before the meeting, and you can still vote. So as a customer of the custodian bank, you could simply say, okay, it's your job to satisfy me as a customer, and I want to vote, it's my corporate governance, so why don't you put up the services to make that possible? You're the customer, so, and you also said that there's different practices with the custodian banks. So at one bank you were forced kind of, if you sell the shares, to call them up and say, okay, please deregister, please take back my vote. It's like if I put my car into the service, the guy says, okay, fine, take the car, but please call up the man who cares for the tires, and also the brake man has to be called, because otherwise the service for the brakes is not going to be done. You're the customer, so
yes,
you should tell the bank, okay, here's the problem, we want to vote, there's a registration, deal with it. It's possible under German law, and please don't do it with Excel, because all the other processes is electronified. So Broadridge is an efficient platform. There's other platforms too. That's electronic. You vote your shares electronic. Then once it's at Clearstream, the registration process is electronic, automated. There's no problem. The problem is only that the custodians have a difficulty to collect the votes and put the votes into the share register. So, I mean, it's difficult for the issuers to put pressure to the custodian banks or to Broadridge, and I agree with you, Cas, that Broadridge is only a platform for exchanging information. They get instructions from the custodians, they get instructions from the investors. So it's merely, I think, a problem of putting pressure to the system and to really locate and focus where's the problem. What's your view on that?
No, that is a very good point, and you raised some very, important questions there. Well, we have to keep in mind this all happened in early January, and then going back to your question, Götz, on when did we become aware of this? So for us, this came unexpected. unannounced, and it had unintended consequences. And it came at a time very shortly before a voting season. So as a reaction to this first announcement that there was going to be a soft block, we've had several discussions with pretty much everyone, every key stakeholder in the voting chain, including the global custodians, including the sub-custodians, the local players, including the service providers, ISS and Broadridge. And one other thing that we noticed is that the banks were telling us is that they were not quite aware of what was happening and what was expected of them as well. And this is what Cas, you brought up earlier, is that as voting season progressed, the processes started to change. So again, providing for additional inconsistencies as to how the judgment was being interpreted and implemented into practice. So we are completely aware that German law does not foresee blocking of any kind, but this is clearly an operational matter. It's what you would call a block that is being put in place in order to give the intermediaries sufficient time to process and to meet the expectations under the German law, as provided by the OLG-Köln judgment.
Just one other point to mention is you said this several times, that you don't always nominate the custodian. So
Yes.
the other issue is that while a fund manager may be managing assets on behalf of 10, 15, 100 different clients, some of those clients, the providers of capital, the pension fund or the mutual fund, make the specific arrangements with the custodians. They not only select which money managers to give funds to invest on their behalf, they also make the selection of the custodian. So sometimes it's part of our frustration as well, that it's not necessarily BlackRock or any investment advisor's decision, it's the beneficial owner who has to put that pressure on. And sometimes, frankly, the beneficial owners are not that involved in the voting process. So, I'd almost question how much are they aware of this problem, because if anyone can apply the pressure on the custodians, it's them. And at some level, the asset managers, because they have their own accounts, but it's not exclusively them to apply the pressure. Mm-hmm. That's why Nordea Bank had a unique situation, because they're one house and it's their own funds, and they could just tell their one custodian to do what they say. And they're so large and significant, no one's going to fight them in that capacity. But if it's kind of like herding cats, how do you get, you may have hundreds, if not thousands of client accounts that you're managing assets on behalf of. Each one needs to take up that mantle of opposition to the custodians. It's not easy always to do that.
Yeah, and I think what you mentioned also is till it's at Clearstream, I think, and there is a barrier, a technical barrier, and which we need to overcome. In addition to the registration process from outside of Germany, there's one issue I think as well. But the information I think was very funny when you was informed. How was you? I heard you were called by investors. You don't have the job for this company in Germany for this, but you were called by investors. What was going around in Germany? I heard. So it's a chat going around in the market. So.
As a proxy solicitor, we're speaking to investors throughout the year on many different meetings that are coming up shortly or in several months' time. And as part of those discussions, one of the earliest meetings this year created some challenges, as just heard. And so some of the investors started asking us, what do you know about this soft blocking and this Cologne court ruling? And so we ourselves had to come up to speed pretty quickly to understand what the impact was going to be for our clients as well as the shareholders voting. As I mentioned before, it didn't only affect voting at companies with registered shares, it also had an impact on bearer shares. So part of our task in that learning of this was to try to suss out what the investors were going to do for across the market. It was difficult because they didn't know themselves in some cases.
And Julia, you also were called by board members directly, so which is not always the case, I think.
Not always. The pressure was very high. Absolutely, I think companies were very concerned and were not maybe fully aware of what the implications or what the problems were, why we decided not to vote anymore. I've read in newspaper articles that investors just did not care, and that was particularly frustrating considering the amount of hours we had put in to really discuss the issue, not only with the banks, the voting agents, but also with other shareholders who were facing the same constraints as us. And then obviously during voting season and before, there was quite a bit of clarification work that we did and to try to explain that we had not just decided not to vote, but that we were facing some considerable operational risks when voting with these soft blocks on. So yes, we've had some interesting discussions, and I think ultimately we're looking forward to keep these discussions ongoing, to clarify this is not necessarily an issue of wanting or not wanting, but there are some quite technicalities involved here that affect other stakeholders, for which we not necessarily, as Cas you just explained, have the direct influence over, because the relationship lies within the beneficial owner and the custodian bank.
Götz, can I ask a question? Because I mean, we have a member of the issuer community and a member of the investor community and many issuers in the audience. In terms of, clearly issuers want shareholders to vote. They want the high representation at their meeting. They want to pass their resolutions. Shareholders, we've heard today and you've seen others, they want to vote at shareholder meetings. Neither one of them are creating the problems themselves. They both want to connect the votes in the middle at their annual meetings. But is there any single thing that you as an issuer or you as a shareholder can identify as where the leverage needs to be applied to affect change?
Well, I think from our perspective, definitely communication and could improve. Now, this, as I said, was unannounced and unexpected. I think with unintended consequences. I think that is important to keep in mind. Ultimately, we could have prepared a little bit better, and I think that includes the custodian banks as well. We could have had these discussions much earlier rather than shortly before, or actually right at the beginning of the year when voting season started to pick up. So really having the communication is definitely helpful. But ultimately, I think there may be some things that can be done to facilitate or alleviate the problem. And I think we talked about earlier the introduction of a record date, and that can definitely ease things up from an investor point of view.
Yeah, the technical record date was mentioned, but there is an issue. It's only it's a little bit of individual, because some issues don't have the technical record date.
As Mr. von Nussbaum said before, normally we have 7 days before the AGM. There might be some issues who have a different date. They can go to 3 days before the AGM. But I think in general it's 7 days before. Mm-hmm. And I think...
and we're talking about a record date 10 days prior to the AGM, so each investor and intermediary knows there is one record date for each company. It must be calculated up from the date of the AGM, but this is a different kind of record date, I think. Yes.
Yeah, we are in a discussion for, I think, 3 years.
Since 2008, I think.
Yeah, something like this. And there we produced a market standard together with the custodian banks here in Germany, but it doesn't come in place right now. and I don't see that this solution will come in place
Very soon.
very soon, yes. And for that, we also need a change in the law, and I don't see that too. But I think that, as you mentioned before, the communication, especially between the investors and the issuers, would be very helpful in future, that we can put pressure from both sides to the banks, to the custodians, and discuss with them that we both want the same. So the investor wants to vote and we want the votings. So I think we have the systems. We must put this together and discuss it in the whole group. And then I hope we will find a solution.
Is it the regulator who needs to be involved in this?
No, I don't think so.
But to get a record date, we need to have a change in the law.
Yeah, that's
So-
right. But there they say that everything must say, yes, we want this, we want 10 days, 20 days, or whatever before the AGM. And if one of the issuers or one of the custodians says, no, I don't want that, then we don't get this record date.
Yeah, our excuse is that we are talking so long for the record date is the details. So I think what we can say from here right now is that a record date will be helpful to have a standard. Then the electronic communication is one thing. I think the communication between the issuers, the banks, and the investors is also a point we must address. And I think there must be a complete understanding of the process from all sides. There are some difference in the past, so I think there's still something to do. I know that from registrar agents want to sit together and find some other processes or ideas, and also Arbeitskreisnamensakte will talk about issuers. So I think there's still something to do to prevent the problem for next year. Because there is a decision from the highest national court regarding the law, I think, Jens?
Might be during autumn, but we don't know exactly whether they will make a decision this year.
Okay, and what is the decision? I think
what-
we're all
yeah.
not sure that they will say the OLG is not right, so it's a little bit different. So I think we're through so far. Any questions from the audience again about this? Which one of you have registered shares in the room? Or can we have some hands? Okay, so very broad interested, the audience. Thank you very much. Stefan Nussbaum again.
Yeah, first of all, thank you very much for the very good discussion, and I must say I do agree with your summary as well, with most of the points you made during this discussion. I would like to take the opportunity to also share some of our experience as an issuer. My name is Konrad von Nussbaum, as you already said, from Allianz Adeus, and we also keep the share register of Allianz and other companies. So we also have registered shares as Allianz, and we also have seen a severe loss in presence and participation in this year's annual meeting, which was, as you also said, Götz, Dickert, quite surprising. We didn't foresee this in this amount. And one reason is that we have in our statutes a rule that says that nominees cannot be registered for more than 3%, and also if they want to be registered up to 3%, they have to disclose any of their customers who hold more than 0.2%. So the result of this rule in our statutes was the same as the court ruling from OLG Köln. the result was that all beneficial owners were registered for the general meeting for voting. And that was a running process for the last 3 years. It may have been quite burdensome for some of the custodian banks, but as Julia, you said, there was difference between the custodians. Some of them could deal very well with it, others couldn't because they have invested less in their systems and they were still working with Excel files. So our first impression was that it was going to work. Now, on a bigger scale, it didn't work as well as in the past. But the fact that it worked for 3 years for Allianz and also other issuers who have a comparable rule in the statutes makes me quite optimistic that there is a way to deal with this problem. Because, as I said earlier, there is no share blocking under German law. It's only a soft blocking that's applied by the processes of the custodian bank. And most of the process is electronified already. And I also agree with you, Cas, that we want investors to vote, and investors also want to vote. But the third thing is we also want to know who our investors are. So the general kind of goal which German issuers of registered shares set is that also beneficial owners from abroad are registered in the register, so we know who they are. And normally they don't want to hide from the issuer. It's more a technical problem that they are not in the register and that there's nominees in the register. So coming from this common goal of investors, issuers, and well, I would also say that that's kind of a role model for the custodian banks. It should be possible to kind of fill this little gap in the process where the vote comes to the custodian and has to be forwarded to Clearstream. That's, I would say, the gap. The rest is also ready, already there and in place. And kind of to put the whole problem into perspective, of course, there's a lot of nominees in the German share register. In the DAX, it's between 80% and 20%. But on the other hand, all German shareholders, institutional as well as private, are registered every day in the share register, every evening, and it's a kind of updated information every day. So there as well, the system works. We should only make it work also for the cross-border registration. And I'm quite optimistic that this is something we can deal with, and we will certainly continue our talks between the registrars and the issuers and also the investors, and we've been talking quite for a while. It's not always been easy, but I think the common goal is there that says, okay, we want them to vote and we want to know who they are, and most of the system is there. And I absolutely agree that I mean, it's not up to date to work with Excel files at this point. There should be a system like Broadridge and Clearstream that allows the custodian banks to forward their information to Clearstream and then to register the shares. And once again, it's not a blocking under German law, it's a blocking that's applied by intermediaries.
And that's evidenced by the fact that German investors don't face the same hurdles that the overseas shareholders do.
And as to the question whether this has impacted or has our chairman of the board of the supervisory board has also addressed this issue on our general meeting explicitly, and he said, okay, this is a severe loss in the participation in the general meeting, as you showed in your chart, and this is a situation which we can deal with in this year, maybe in the next year, but it's not a sustainable situation to have a general meeting presence of 29%. So he also said this is something we have to deal with. So the promise is, I would say, from many issuers to kind of take this issue up together with the other participants, and that's I think our statement on the record date will be helpful. We've been talking about that for a while as well, and we also support this. So I think there's a kind of light at the end of the tunnel.
Just if I can add one point to something you just raised, a low vote turnout creates a liability or a risk factor in terms of a company being targeted by activists. So some activists look at companies with a low vote turnout so that they can have a disproportionate impact on future resolutions if they come in with a 3 or 4 or 5% stake. They'd still have to declare themselves, but if they know that the total vote turnout is going to be 20, 25%, their 6% can have a very significant impact on what their objectives are, not what management's objectives are.
Yeah. So, thank you very much. We discussed this now. We hope we have a lot of work to do again to help the situation a little bit for the next years. And thank you very much.